NASCAR is facing a significant legal challenge that could transform the face of stock car racing in the United States. A federal court verdict on December 18th dealt a huge damage to NASCAR's long-standing governance structure, awarding a substantial victory to 23XI Racing and Front Row Motorsports. This move effectively grants these teams charter status for the 2025 NASCAR Cup Series season, revealing flaws in NASCAR's processes and raising serious concerns about how it handles team agreements. But what NASCAR did next truly shocked fans and teams. To grasp the depth of the situation, we must first study the charter structure, which serves as the foundation of NASCAR's top-tier racing. Introduced in 2016, the charter system ensures 36 teams a spot in every Cup Series race, as well as financial incentives. This system was intended to provide stability while increasing the value of team ownership. However, the system has become a source of disagreement, resulting in the ongoing court battle. The controversy began after 23XI Racing, co-owned by NBA legend Michael Jordan and NASCAR driver Denny Hamlin, and Front Row Motorsports, owned by Bob Jenkins, refused to sign the 2025 charter agreement. This refusal followed nearly 2 years of tense discussions between NASCAR and its teams. In September, NASCAR issued a take-it-or-leave-it offer, giving teams only 48 hours to accept before the playoffs began. 23XI and Front Row were the only 2 teams out of 15 that refused to sign the new deal. In response, they filed an antitrust claim against NASCAR and its chairman, Jim France. The teams claimed that NASCAR, as the only important stock car racing corporation in the United States, had a monopoly and that teams do not receive a fair part of the sport's earnings. Initially, the team's demand for an injunction was denied. However, a watershed event occurred when Judge Kenneth D. Bell overruled the prior verdict and issued a limited preliminary injunction for the 2025 NASCAR Cup season. This verdict permits 23XI Racing and Front Row Motorsports to enter 2 race cars apiece in all NASCAR Cup events, with the same benefits as other charter teams. The court's ruling was based on 2 essential considerations. First, it acknowledged that drivers' contracts may be terminated if the teams fail to gain charter status, endangering the survival of 23XI and Front Row Motorsports. Second, and probably more importantly, the court held that the charter agreement's limitation on filing litigation in exchange for membership violated federal antitrust statutes. Judge Bell's ruling stated, "The parties to this action cast their existential dispute in starkly different terms." According to plaintiffs, NASCAR, led by the dynastic France family, is the iron-fisted, monopolistic ruler of premier stock car racing that has imposed anti-competitive take-it-or-leave-it terms on plaintiffs and other top-tier racing teams. In defendants' telling, NASCAR and the France family are the founders and guiding lights of a beloved and valuable racing series who have fairly negotiated mutually beneficial charter agreements that reflect reasonable commercial terms between NASCAR and the race teams. The judge concluded that these competing narratives could not be resolved through a motion to dismiss, stating, "What is the actual evidence, and how does it inform a correct legal conclusion? These questions cannot be determined on motions to dismiss in this action, where plaintiffs have sufficiently alleged 1 or more plausible antitrust claims against defendants within the applicable period of limitations." This decision has far-reaching consequences for both the teams involved and NASCAR as a whole. It guarantees 23XI Racing and Front Row Motorsports' right to compete as full members in the 2025 season, averting potential existential concerns such as the loss of sponsors and driver contracts. Tyler Reddick, for example, had a provision in his contract with 23XI Racing that permitted him to become a free agent if the team lost its charter status. NASCAR will suffer far-reaching and varied ramifications. The decision undermines the organization's planned structure for the 2025 season, forcing them to pay millions in pool money to 23XI and Front Row Motorsports. These monies were previously allocated to other teams and promotional projects. NASCAR now has the issue of reallocating financial resources while meeting the expectations of the other teams who signed the charter agreement. Furthermore, the court's judgment reveals flaws in NASCAR's governance mechanism, which could harm its reputation. The verdict calls into question NASCAR's ability to manage conflicts in an ever-changing market, especially as newcomers like Michael Jordan's 23XI Racing want a greater say in the sport's destiny. NASCAR's original reaction to the complaint now appears foolish. the sanctioning body has planned for a 2025 season without 2311 Racing and Front Row Motorsports, going so far as to remove their names from registration lists and reallocate prize money to other teams. This rash plan not only overestimated the rival team's legal power, but also exposed internal dysfunction within NASCAR. In order to limit potential damages, NASCAR obtained a Rule 65B bond from the court. This bond would have forced 2311 and Front Row to set aside funds to cover the charter money they would get in 2025 if NASCAR won the lawsuit. NASCAR maintained that if the teams were proved to have been illegally granted charter status, it was entitled to reclaim the money. However, the teams fiercely opposed this demand. Michael Jordan's legal team contended that the charter payments are not a windfall, but rather reimbursement for the club's charter-related obligations. These requirements include competing in all races, allowing NASCAR rights to their intellectual property, and following restrictive covenants. In a daring move, the teams requested a $500 bond, emphasizing that NASCAR suffers no cost by upholding its own charter agreement. Judge Bell agreed with the teams on this point, writing in his decision, "However, the court finds that, at least at this point in the litigation, NASCAR has failed to particularly establish how it, as distinguished from third parties, will be monetarily harmed, or in what amount by having to pay plaintiffs as chartered teams." The judge also pointed out NASCAR's lack of detail in its plans for the contested cash. NASCAR says it may use the money to encourage new teams to join or promote the sport, but hasn't given the court any specifics, stating only that the finalization of its plans is forthcoming. Furthermore, during oral argument, plaintiffs stated to the court that NASCAR has informed its chartered teams that it plans to retain a portion of the fixed pool money to cover legal costs in defending this lawsuit, and claimed that NASCAR did not dispute. The lawsuit also raises concerns about NASCAR's capacity to resolve disagreements in a changing landscape. By alienating high-profile owners such as Michael Jordan and failing to anticipate the lawsuit's broader repercussions, NASCAR risks damaging its credibility and operational stability in the long run. To deal with this situation, NASCAR must explore many strategic options. First and foremost, the organization must emphasize open conversations with 2311 Racing, Front Row Motorsports, and other stakeholders. Working toward a settlement could allow NASCAR to retake some control of the issue. This could include compromising on revenue sharing to align all parties' objectives, rewriting the charter agreement to resolve antitrust concerns, and providing incentives for collaboration. Furthermore, NASCAR must conduct a comprehensive assessment of its charter structure, upgrading agreements to better balance team autonomy and NASCAR's objectives. Increasing the flexibility for open teams to shift to chartered status and instituting protections to prevent against potential antitrust challenges would indicate NASCAR's dedication to growth and fairness. While the legal dispute has presented obstacles, it also provides an opportunity for NASCAR to capitalize on the extra attention generated by high-profile people such as Michael Jordan. NASCAR can position the verdict as part of a larger attempt to modernize the sport and make it more appealing to new teams and owners. Strategic marketing efforts stressing competitive racing and new narratives may help shift the focus away from the lawsuit and toward the sport's growth potential. NASCAR must rethink its financial priorities in order to deal with the ruling's consequences. This may entail deferring or reducing non-essential growth activities, prioritizing high-impact investments such as fan engagement, and looking for new sponsorship options. A rigorous review of spending will be required to maintain sustainability during this volatile period. In reaction to the lawsuit's ruling, NASCAR is making numerous substantial modifications for the 2025 season. The damaged vehicle policy has been revised, allowing cars to be fixed at the garage with no time constraints. The playoff waiver regulations have been modified, with drivers forfeiting playoff points for non-permissible race absences. In response to concerns about race manipulation, NASCAR has defined penalties for manufacturer breaches. A major feature is the Open Exemption Provisional, which creates a potential 41st starting slot for experienced drivers in select races. This has already been granted to Helio Castroneves for the 2025 Daytona 500. NASCAR has recently changed its suspension policy, allowing for the deferment of technical penalty bans. These modifications attempt to provide a more flexible and egalitarian environment for teams while protecting the sport's integrity. However, their ability to resolve the difficulties raised by the case remains to be seen. What do you think? Let me know in the comments down below.